Counsel, for Mr. Brown's benefit, why don't you go ahead and lay out your motion on the record?
Previous matters to attend to is that when I was preparing this file, I saw that, and I don't know if the court received it, if he filed or not, but there was an opposition to the notice of intent or to dismiss, to default, that was received by my office yesterday.
No, that has not been filed in the court file. I appreciate your candor to the court on that. Mr. Brown, did you file paperwork disputing their default judgment and send a copy of that to American Family's attorney?
Yes, correct.
Okay. So, sir, did you also file a copy of that with the court here at the clerk's office?
Yes, correct.
Clerks, do we have any notes indicating whether or not anything was received in the last 24 hours or so? So my clerk informs me that something may have been returned to you because it was not in a court format, sir. I don't know what that is, but you may want to, before I say what you may or may not want to do, I can't give you legal advice, but counsel, if he attempted to file something disputing the default judgment in your office, what do you want to do?
I'm fine to actually try to suss out whether an answer, well, in that document, he notes that an answer was filed, but we've never received an answer.
There's no answer in the court file.
He did send us a motion to dismiss at one point, which we did file an opposition to, but he never set a hearing and nothing ever happened. And I don't know to date whether that actually qualified as an appearance or not, but that is why we had sent the notice of intent to default to him. We basically didn't know what next to do because there was no hearing set, so nothing, we didn't know if the motion was going to be heard good or how that was going to work out. I'm happy he's appeared here today. I'm happy to address that motion if it is in the court file, or to have him file an answer or go over why the motion to dismiss was not valid because it wasn't based on CR 12 or.
Sir, you need to file and figure out how to file things in proper format with a court. I recognize the rules can be very difficult for someone who is not a trained lawyer. I very much understand that, but you do have to do your best. I mean, do you want me to take, I guess, sir, do you want me to hear your motion to dismiss, or were you expecting to talk about your motion to dismiss today, Mr. Brown?
I was not aware that a motion to dismiss was never served to the court.
Well, it was, sir. The motion to dismiss was served on the court. But what I understand is there may have been something mailed to the court yesterday and that you sent to American Families Council within the last day or two. That's what's not been filed yet. So I have a motion to dismiss from you dated October 17.
Yeah.
Are you wanting to argue that motion to dismiss today or not?
I'm not prepared for that.
Okay.
I'm willing.
That's fine, because I can't see what was filed, but it may colorably be an answer. So, sir, if you want me to consider that, you're going to have to figure out how to file it in court in the correct manner. I can't tell you how to do that. I can't give you legal advice, but that needs to get done. So, counsel, what I would say is I recognize this is somewhat of an odd posture, but if you believe that there is a basis to go forward on a motion for default, I'd ask you to renote it. If you believe that in good faith he has attempted to answer, you can take whatever steps you want to deal with how you want to deal with that next.
But I will try to get in touch with him and try to figure out next steps.
Yeah, I appreciate that. I mean, without seeing what he gave your office, it's hard for me to figure out if it could colorably constitute an answer or not.
Right. Understood, Your Honor.